Under the revised Corporation Code, the Securities and Exchange Commission abandons passive registration. The statute now establishes an enforcement-heavy posture, giving the regulator the authority to intervene directly in corporate affairs. Title XVI provides the quasi-judicial powers necessary to execute this role. It outlines specific mechanisms to investigate violations, halt ongoing practices, and impose significant financial penalties on entities and individuals who fail to comply. Within this framework, the corporate veil is treated as a limited protection. When statutory violations are identified, the law bypasses the entity's separate personality to target the specific people responsible for the misconduct. These powers follow a 5-step sequence: investigation, subpoena, cease and desist orders, the identification of specific offenses, and finally, the imposition of personal liability. Understanding Sections 154 through 171 requires a focus on the mechanics of each power and the specific defenses available to a corporation. For those preparing for legal examination, these provisions contain specific traps regarding jurisdiction and notice. Collectively, Title XVI changes the consequence of noncompliance. In this system, the privilege of the corporate franchise is strictly tied to the immediate and aggressive oversight of the SEC. The process begins under Section 154, which grants the SEC the power to investigate alleged violations of the Code. Following an inquiry, the Commission may publish its findings and advisories to inform the general public or the specific parties involved. This power is not unlimited. The publication of findings is strictly subject to the Data Privacy Act of 2012, requiring the SEC to respect statutory data privacy rights during its investigations. Section 154 also contains a specific jurisdictional requirement. Before publishing findings involving companies under special regulatory jurisdiction, such as banks, the SEC must give reasonable notice to and coordinate with the appropriate agency, like the Banco Central ng Pilipinas. Section 155 extends this authority by granting the SEC quasi-judicial fact-finding powers. Designated officers are authorized to administer oaths, summon witnesses, and take testimony during any investigation. Unlike standard civil litigation, the SEC does not require a court order to compel the production of internal corporate books. This direct statutory grant allows the Commission to issue its own subpoenas and subpoena duces tecum. These three mechanics, oaths, subpoena, and testimony, form the OST mnemonic, representing the foundational tools of an SEC inquiry. Because Section 155 provides this power directly, a corporation cannot use the absence of a judge's order as a valid defense to obstruct an official investigation. Section 156 introduces the Cease and Desist Order, or CDO. This is used when the Commission has a reasonable basis to believe a person has violated or is about to violate the Code. A CDO can be issued ex parte, meaning without a prior hearing, if the act is fraudulent or expected to cause imminent and irreparable injury to public safety or welfare. The ex parte order is a temporary measure. It is valid for a maximum of 20 days. To make the order permanent, the SEC must conduct a formal hearing and provide due notice to the parties involved. The rules of Section 156 follow the CE20P mnemonic: CDO for violations, ex parte for emergencies, a 20-day limit, and permanent status only after a hearing. If a party refuses to comply with these orders, Section 157 authorizes contempt charges. This carries a fine of up to 30,000 pesos. However, if the refusal is an act of open defiance, the SEC can impose a daily fine of 1,000 pesos until the order is met. A common error is assuming these fines are automatic. Section 157 explicitly requires due notice and a hearing before a person can be held in contempt and fined. These provisions allow the SEC to apply escalating financial pressure. By increasing the daily cost of defiance, the Commission can force compliance without initial court intervention. Section 158 lists scalable administrative sanctions. These range from fines between 5,000 and 2 million pesos to the suspension or revocation of the certificate of incorporation. For the most serious violations, Section 158, paragraph D, authorizes the dissolution of the corporation and the forfeiture of its assets. Under Section 159, the law penalizes the unauthorized use of a corporate name. Operating under an unregistered name or a name the entity has no legal right to use results in a fine ranging from 10,000 to 200,000 pesos. Section 160 focuses on individual eligibility. It penalizes any director, trustee, or officer who willfully holds office or conceals a ground for disqualification, such as a prior conviction for fraud. The mnemonic DWP summarizes the penalty. A disqualified person who willfully holds office faces a permanent ban. If the violation is injurious or detrimental to the public, the penalty increases. The fine is doubled, ranging from 20,000 to 400,000 pesos. This disqualification is comprehensive. Under Section 160, the offender is barred from holding a position in any corporation registered in the Philippines. This measure protects the registry by excluding actors with documented records of misconduct from the corporate system. Section 161 penalizes the unjustified refusal to allow a stockholder to inspect or reproduce corporate records. These fines range from 10,000 to 200,000 pesos. If the refusal to allow inspection is based on a board resolution, Section 161 shifts the liability. The statutory fine is imposed directly on the specific directors or trustees who voted for that refusal. This does not apply if the refusal is justified. A corporation has a valid defense if the requesting party is a competitor or is not acting in good faith for a legitimate purpose. Accuracy in reporting is covered by Sections 162 and 163, which address false statements and auditor collusion. Any person who willfully certifies a required report, knowing it contains false or misleading information, faces a fine of up to 200,000 pesos. Auditors face even higher penalties under Section 163. Colluding to certify inaccurate or fraudulent financial statements can result in a fine of up to 600,000 pesos. Section 161 ensures that individual decision-makers are held responsible for obstructing transparency, preventing the board from using the corporate entity to hide individual actions. Section 164 targets the formation of a corporation through fraud. If the violation is injurious to the public, the fines scale up to 5 million pesos. The read of Section 164 includes those who assisted directly or indirectly in the fraudulent formation. This provision can be applied to complicit professionals who draft or submit the fraudulent documents. This is distinct from Section 165, which applies when a corporation is formed legitimately but then conducts its ongoing business through fraudulent means. Corruption is addressed through Sections 166 and 167. These use the EIG mnemonic, engaging an intermediary for graft. Section 166 penalizes the intermediary, the corporation used to commit graft. Section 167 penalizes the entity that hired that intermediary for its own benefit. These provisions address the use of corporate structures to facilitate bribery or conceal corrupt practices. By setting fines in the multi-million peso range, the law seeks to make corporate fraud and corruption financially unsustainable. Section 170 is a catch-all provision. Any violation of the code not specifically penalized elsewhere is subject to a fine of up to 1 million pesos and the potential dissolution of the corporation. Section 171 establishes the relationship between the entity and the individual. If the offender is a corporation, the penalty may be imposed on the corporation and the specific individuals responsible for the act. This is determined by the responsibility test. Liability applies to those who are responsible for the violation or whose participation was indispensable to its commission. Under Section 171, the corporate veil does not shield individuals from penal liability. Traditional defenses based on separate personality are not applicable to these offenses. From initial investigation to final dissolution, the SEC's power culminates in the direct accountability of management and the board. Title XVI has created a new standard for corporate governance. For any corporation operating in the Philippines, the privilege of the franchise is now strictly dependent on total statutory compliance.